Right. Good afternoon. This is about some of the difficulties with enforcement of environmental law at ground level. And my initial objective when preparing the talk was to look at the problems and suggest some changes to legislation that could be made in order to achieve better enforcement. But we've a saying at home: if you're looking for another piece of lemon, squeeze the one you have first. And as I looked at the problems and how you would fix them, I began to realise that a lot of what I'm about to suggest could actually be accomplished within the existing legislative framework. I plan to deal with the issue under a number of headings. I'm going to look at the principles that we're trying to achieve through enforcement, and then look at the measures that can be adopted: the notices, criminal prosecutions, injunctions, penalty payments, and financial security, all of which form the package of measures for enforcement of environmental law. European law gives us, or environmental law as a whole, both at the European and the international level, gives us an intellectual framework for what we're trying to achieve in enforcement. And it's based on the principles that I'm sure are well known to everybody here, so I'll just rattle through them. Environmental enforcement is about protection. It's protection of the environment, conservation of species and habitats, and preservation. And that's to be achieved through prevention of pollution and a precautionary approach. Where prevention doesn't succeed, we're trying to achieve remediation. All of that is within a context of sustainable development, on the understanding that we do want developments because many of them are beneficial in terms of health, longer life, and benefit to the environment, as well as economic development. And finally, that's all underpinned by the polluter pays principle. That is, the person who creates the risk should bear the cost of prevention, and the person who causes the damage should bear the cost of remediation. It should not be borne by the neighbours of a polluting industry. It should not be borne by the state. It should not be borne by the citizens of the state. And it should not be borne by the environment. It is the polluter who should pay, and enforcement tries to achieve that objective. I think it's important to understand where we come into the whole picture of enforcement as lawyers. Most people want to comply. They want to do the right thing. And even if they don't particularly want to do the right thing, they don't want to infringe the law. They're prepared to be reasonable. And they're open to be persuaded and cajoled into complying. And sometimes you may need to bully them a little bit. And that's the stage at which serving a notice on them, requiring them to do something, comes in. And it's really only after that stage that there's any role or involvement for lawyers. And essentially, we're a bit like the black spy and white spy in Mad Magazine's Spy versus Spy, taken off the internet there. There was no copyright attribution, so I swiped it. And, you know, one day we're the good guys and the next day we're the bad guys. And on enforcement, I like to think I'm the good guys. On Karen's Moville case, I'm the bad guys. And there's a whole other story to that, but we're waiting for a judgment, so we won't go near it. But I sometimes get a bit peeved when people turn up at conferences like this and say, why can't we all just get along? We're lawyers. It's not our job to be getting along. That was something that our clients should have been doing before they got to us, and maybe there's some residual possibility for a deal. But essentially, by the time we're involved, we're dealing with the hardcore of people who simply will not comply unless they're forced. And the one improvement that could be made in respect of notices is to tighten them up and to say very precisely, you must do this, this, and this by 5 p.m. on such a day, and report to us when it's done. And if you do not do so, the following are the potential consequences. And so the final stage in a notice procedure is essentially a precursor to more serious enforcement action, such as a prosecution or an injunction. In relation to prosecutions, maximum fine in the district court under the Fines Act for an environmental offence is €5,000 or 12 years in jail. Sorry, 12 months. You wouldn't want to get that wrong on the order. And that, it strikes me, is in one sense completely inadequate, and in another sense it gives rise to massive disproportion, because an individual who's prosecuted can be sentenced to both, but a company is only liable to the €5,000 fine. So a company, even a global corporation, is subject to a much lower penalty in the district court than an individual is. Secondly, that fine of €5,000 is going to weigh much more heavily on a small company than it is on a large one. And looking for a different model for penalties, it's perhaps instructive to look at European competition law, where the European Commission can impose a fine of 10% of turnover on a company that participates in an unlawful cartel. And maybe percentage turnover would be a better basis for fines both in the circuit court and in the district court. In the circuit court, the maximum fine is in the order of €10 million. But whilst that might be way above what would be required for most offences, if you imagined a disaster on the scale of the Bhopal disaster in India, it's hard to conceive that 10 million would be an appropriately large fine if you had thousands of people dead. So if we were to have a system based on turnover of the company, 10% for the circuit court, and I'd suggest 1% for the district court. And there'd obviously be things to be worked out in that. You'd want to make sure that somebody couldn't be subject to 10 1% fines in a year because they'd committed 10 minor offences. And subject to that, I think there should be a legislative amendment providing a proper fine structure for environmental offences, particularly in the district court. There's some other matters there. I won't actually go into them because I know we're under time and they're dealt with in my paper. If I move on to injunctions, injunctions are great for getting people to stop doing something unlawful. Under injunction procedures, I've been involved in closing down unlawful waste operations in Kildare, in Laois, they were the main ones. Dublin Waste and Dean Waste are out of business as a result of injunctions brought by the EPA. There's also a piggery near Mitchellstown with an effluent producing capacity equivalent to Cork City now lying empty as a result of action taken to stop the horrendous practices that were going on there, with slurry just leaking out all over the place. A massive tank possibly the size of this theatre, that was liable to collapse at any time. And in the midst of it all, the pig population of the piggery starving because the operator said he couldn't even afford food for them. And injunctions are great for stopping things that are unlawful. What they're not so good at, or not so good for, is compelling people who do not want to remediate to remediate. The principal route for enforcing a remediation obligation in an order is by attachment and committal to prison. And if you want to go down that route, you have to first persuade the court that there has been a contempt of court. So you have to serve the order on the defendant, even if he was present in court, even if he consented to the order, you have to serve it on him. Then you bring your motion for non-compliance. He has an opportunity to respond. He discharges his solicitors. He represents himself. He takes on other solicitors. They need an adjournment to take instructions. They put in a replying affidavit, which you then need to reply to because it doesn't address the points. And he then needs another reply. And you finally get your hearing, and the court finds that the defendant is in contempt. The defendant then gets an opportunity to comply. He doesn't comply. So you have to prepare an affidavit saying that he hasn't complied and he needs an opportunity to respond to that. And you get your hearing date, and you have to update your original affidavit to say, well, he hasn't complied in the interim since we swore the first one. And you go in on the day and he's looking for a further adjournment to put in another replying affidavit. And eventually you get your hearing, and maybe he gets a second chance, or maybe he's ordered to go to jail. And if he's prepared to go to jail, which has been the case. In one particular case, we had Scullies we had committed to prison for 6 months, and they were prepared to do that rather than find the money to carry out remediation. By the time you come to the end of the 20 or 30 court hearing dates it takes to get to this stage, your client and your counsel are exhausted, and there's very little appetite to keep on effectively throwing good money after bad. So there's got to be a better way. And the rules of court provide for garnishee orders where you can order somebody to pay a debt they owe to the defendant directly to you. So you can go after his bank accounts, if he has bank accounts, if you can locate them. But you can only do that if you have an order for the payment of money. And the same goes for sequestration of assets. The defendant's assets can be sequestered by order of the court, but it's to pay a debt. So maybe if we were to revisit the original order before it was drawn up and say, well, instead of simply an order to stop and to remediate, we add in a provision that in default of compliance, you shall pay to the plaintiff the estimated cost of the plaintiff carrying out the compliance measures, because both the agency and the local authorities in enforcement cases have the power to do the work and to recover the cost of doing so. So if the order provides for payment in default, then you can rely on that as a basis for your garnishee order or for your sequestration. An alternative possible approach, and I don't know if it would work because it hasn't been tried yet, is to appoint a receiver by way of equitable execution to the defendant's business. And the difficulty with that seems to be that the plaintiff must show that he has an equitable right that is enforceable. And in theory, an injunction requiring you to do something is, I think, an equitable right. But I'd like to test that out before I stand up here and say more categorically that that is the case. And possibly, if you have an order for payment of a sum of money, you may lose your equitable right, because what you're looking at is an order to pay what's effectively a debt. Is a legislative amendment required for that? I'd like to try the existing procedures and see how they work before saying it is. Moving very, very quickly on, there's a possibility for suspension of a licence if the licensee ceases to be a fit and proper person to hold one. That's if they've been convicted of an environmental offence, if they lack the technical competence to carry out the activity, which they may demonstrate by not complying with the licence, or if they lack the financial ability to meet the commitments or liabilities that arise from carrying on the activity. Suspension would be more useful as an enforcement tool if it was available in cases of non-compliance. Simply put, if it just said, if you fail to comply, your licence may be suspended. but it does have some potential to be used, although you might be just as well serving a notice and bringing an injunction. In fact, in one case, which we brought the Environmental Protection Agency against Euro General, it was brought under the WEE regulations in relation to a child's toy gun, that had a light and a sound in it, but was painted with lead paint. And the agency wanted the defendant to issue a recall notice, and it had power under the regulations to order the recall of the product, or to order the publication of the notice for recall of the product. The defendant had a right of appeal to the circuit court, which he exercised, and we promptly brought in an injunction in the High Court, which the agency had a right to do, whereupon the defendant folded and published the notice. The defendant argued that the agency had been wrong to bring an injunction application when the notice requiring recall was outstanding, and Judge Hedigan held that it was entirely appropriate for the agency to do both. So you can have a combined approach. So you could go for an approach of suspension, which carries a right of appeal, coupled with injunction, or you might decide that a straightforward injunction was a better route. Penalty payments have been floated. How am I doing? 2 minutes. Okay. Penalty payments, they've basically been long-fingered. There's no action on them, but you could structure something similar as a compensatory payment. I initially thought of maybe structuring it as a charge payable to the agency for excess emissions, so that if you emit, say, 1 tonne more than your emission limit of a particular substance, you must pay so many euro. There's actually provision in the EPA Act for the Minister to make regulations creating such a scheme. There are no such regulations in being, and the fact that there's a power to create regulations suggests that it may not be possible to do it by straightforward condition of the licence. But if you said this money is for remediation and it is to be held by the licensee and applied either to remediate the effects of this emission, or where that cannot be captured, to remediate the effects of similar emissions, you could create a system that was analogous to a penalty payment system, but without the penalty element in it, and you could do that within the existing framework. Finally, financial provision. I've been doing a lot of work recently on the financial provision that licensees put into place to guarantee their compliance with their license obligations, and to ensure that there's a fund in place when they fail to comply. And what I'd really like to achieve would be a system similar to what's provided in the Fines Act, where you can appoint a receiver to go in and achieve compliance. So rather than just trying to collect the fine, You'd appoint a receiver to take over the business and run it in a manner that complies with the environmental obligations, sells off as much as may be necessary to fund any remediation. And thinking about it, I think that can be built into a financial obligation. First of all, you get an undertaking from the licensee to comply. Licensee covenants to pay the costs of the remediation or prevention measures, enters into a bond to pay the estimated costs, and also gives a charge on the assets of the company, and that charge would be coupled with a power to appoint a receiver. I think the agency has power to do that at the moment. That's just my view. In conclusion, I think there's a suite of measures that can be put in place to improve enforcement. And listening to the other talks this morning, I just say, well, I'm working on this lemon, but can somebody buy some more? Thanks.